conclusions that there was a failure of full and frank disclosure, material non-disclosure in the ex parte hearing. An application to proceed ex parte should not be taken lightly and can only be justified in exceptional circumstances. And when making such an application, the applicants must be assiduous to ensure that all parts of the relief are truly necessary to obtain ex parte. Secondly, that in respect of each element of the relief, it goes no further in scope than that which is required on an ex parte basis. And thirdly, that all material matters are specifically drawn to the court's attention under the obligation of full and frank disclosure. My learned friend has, in his able submissions, suggested that our application to set aside the order made by Mr. Justice Constable was purely on the basis of a failure of full and frank disclosure, as if that's a minimal application. But it's not, he says, made on the basis that there was a failure to apply American cyanamide principles. It's very difficult to challenge a decision on American cyanamide principles, but the application that we made suggesting that there was a failure of full and frank disclosure was one of the most serious applications in respect of an ex parte application which should never have been made and shouldn't be downplayed by my learned friend. And he complains about the effect it has on his clients, that they are now deprived of fruits they could have obtained had they done things properly. But that is the effect of having an order discharged following the law, which I'll show your lordship soon. So I will plunge straight forward into the grounds of challenge. I'm not going to deal in the background information. And the first ground was whether Mr. Justice Bourne was entitled to find that there had been a material non-disclosure. My learned friend Mr. Kinman, in his able submissions just now, reminded this court of the generous ambit afforded to first instance judges when he said that our respondent's notice should be dismissed. And he's right to remind the court of the generous ambit afforded to first instance judges, but that applies, of course, to every single one of Mr. Grant's submissions. A decision made by the first instance court, made in this case by Mr. Justice Bourne, can only be impugned if there was an error in principle, or if the judge took into account immaterial matters, or failed to take into account material matters, or made a decision which was otherwise impermissible. It's not enough for my learned friend to say to your lordships that your lordships might have made a different decision. This court must be required to come to a different conclusion, and the burden is on the appellant, and authority for that is the Subesh and Secretary of State for the Home Department decision, which is referred to in my paragraph 10 in our skeleton argument decision of this court. Furthermore, the reticence of the appellate courts to interfere with the lower court is not engaged solely where there has been oral evidence, but applies to any decision where there is an evaluative exercise. So in fact, the case of Malik and Henley Holmes, a decision of this court from last year, which we've referred to in paragraph 10, was a decision of the Court of Appeal upholding a judgment on summary judgment, where there was no evidence heard, and it might be thought that's a question of law. But the Court of Appeal referred to the reticence of the appellate court to interfere. And that reticence, my lords, is increased where there is an evaluative exercise undertaken by the court, as there was in the present case. My learned friend has repeated on a number of occasions this morning to your lordships that Mr. Justice Bourne got the law wrong, didn't set the law out properly and misunderstood it. And with great respect, he is wrong. May I show you why? Firstly, both sets of barristers in their oral and written submissions referred accurately to the law. So, for example, in Mr. Siddle's skeleton argument, which can be found behind tab 9 of the supplemental bundle, your lordships can see at paragraph 16, page 147, supplemental bundle, tab 9.
Yes, thank you very much. Sorry, I was given my Lord's bundle. Not helpful to either of us. Can you give me the reference?
Of course. Supplemental bundle, tab 9. And I'm reading from paragraph 16, page 147. You can see there that Mr. Siddle referred to the case of Brinks-Matt and Elcombe.
Yes.
The onus being on the applicant to make full and frank disclosure. Materiality at paragraph B means material to court in determining the application of the objective question. The applicant's got a duty. And then over the page at page 148, paragraph 20, my learned friend Mr. Siddle referred at length and quoted at length over a number of pages to the National Bank Trust and Euroff case. Similarly, in my skeleton argument, our skeleton argument behind tab 10, at paragraph 22, page 186, paragraph 21, I refer to the Bank Mellat and Nick Poor case about the duty of full and frank disclosure being one of the most fundamental importance, and then at paragraph 22 I refer to the Brinks-Matt case, and then going forward to page 200, paragraph 61, on the effect of non-disclosure, we set out the principles in Arena Corporation and Schroeder, namely that the general rule is that if there's a failure of full and frank disclosure, the order should be discharged, and that the jurisdiction, little 3, to regrant should be exercised sparingly.
Is that right, actually? Number 1, the general rule is that it should discharge the order. Is there any other authority other than the Deputy High Court judges in this case that says the general rule is? I've just noticed, as Justice Mason said in the other case, a likely starting point if it's substantial or deliberate is discharged, but this is to put it much more strongly.
Can I come back to that point, my lord? But the submissions on the law were not an issue. Those submissions were not an issue before the judge, and you can see that because at in the transcript at paragraph 13.
Sorry, where are we looking now?
The transcript behind tab 13.
Right, thank you.
At page 250, at C, this is my submissions, I referred to the First Express case, where Mr. Justice Hoffman was talked about the obligation of going ex parte, the only reason being that D, the opportunity appears likely to cause injustice by reason of the delay, or appears likely that respondent or others would take action which it appears would be taken before the order can be made. So urgency, or that the defendants would frustrate the order. And then a little further down, I referred to the Brinks, Matt and Elkham principles, and I suggested they were agreed, and Mr. Siddle agreed that they were agreed. And
that I accept. It's these one sentence in the Deputy High Court Judge's decision which appears to, in Mr. Justice Bourne's judgment, I just wonder whether it takes the law into absolute term, in which case that may be an error of by Mr. Justice Bourne.
perhaps that wasn't a point suggested by counsel below. It wasn't a point taken against me, but also in my submission in this instance, the failures of full and frank disclosure are so serious and numerous that the only proper response to those failures would be to discharge the order. So in my submission on these facts, it's a proper statement of the law.
Well, I think as the transcript indicates from page 250, the law hasn't really changed since Brinks, Matt and Elkham, has it? I mean, distinguished judges, including the present lady Chief Justice, have restated them, but actually calling them the Brinks, Matt and Elkham principles is still correct, isn't it?
Yes, yes. And my learned friend has referred to a number of more recent authorities, but yeah, our submission is those don't take the matter any further. They restate the Brinks-Matt principles. Not only were those authorities not put before Mr. Justice Bourne, but the correct approach was put before Mr. Justice Bourne by both parties, and everyone agreed, and that's why Mr. Justice Bourne said in his judgment at Core Bundle tab 6, page 58, paragraph 17, that he doesn't understand there to be any dispute about the principles relating to failures of full and frank disclosure. There wasn't any dispute about that. And he says, where there is any substantial failure, general rule is that without notice order will be discharged. I'm pausing there for a moment. That's accurate in my submission, where there's substantial failure. At paragraph 17. The general rule is that the without notice order will be discharged and not renewed, although there's a discretion to continue or regrant the order, and that's right as well. And that is the basis upon which the judge proceeded to consider discharge and regrant, and that's entirely accurate. So my submission is the suggestion by the appellants that Mr. Justice Bourne misdirected himself as the correct principles is obviously wrong. I accept he didn't set it out in the judgment, but when you're giving an extempore judgment after a long day's argument where there was dispute about lots of matters, but not on this point, it's not incumbent on a judge to set out at length matters of law which are agreed. And another principle that we advanced before Mr. Justice Bourne was that it's insufficient to refer to adverse material in evidence, but the court's attention must be specifically drawn to it. So my Lord Justice Lewis and my learned friend had a conversation about documents which may have been referred to by reference in witness statements or affidavits that had to be followed up in the bundle. But the key point is this: there were significant facts which were adverse to the appellants, which were not drawn to the court's attention. Quite apart from the fact that there were documents which weren't part of the application, even where the documents did form part of the exhibits, they weren't properly referred to. And so there was a failure of full and frank disclosure. And the most significant failure, I don't know, there's a a big choice for me to make about which is the most significant failure. Perhaps I'll put it more neutrally. The failure that we led as failure number one, and which I advance now as failure number one, which Mr. Justice Bourne dealt with first, was proceeding without notice in respect of the non-compete injunction. And Mr. Justice Bourne dealt with this in his Lordship's paragraph 1819, so it's Core Bundle 6, page 58. And he said at 18, there are significant failures. It's logical to seek orders of preservation and imaging orders without notice. The same logic didn't apply to orders restraining him from competing or misusing confidential information. To date, in my judgment, no good reason has been identified for seeking those orders without notice. There was a duty to ensure that the judge was aware of the difference between the rationale for the different parts of the order and the fact that making non-complete confidentiality orders without notice was unusual, to say the least. It's extremely unusual. And not only was the judge, Mr. Justice Constable, not told as of any reason why those orders were being sought before him, there was no reason advanced before Mr. Justice Bourne as to why those orders were sought, nor is there now.
The judge was given the reason in the affidavit.
Yes.
And it may not be a good reason, or it may be a good reason, but it's not right to say he was given no reason.
It's not a reason that accords with the law that was advanced before the judge. So the law is, as I've read out to your Lordship, with Mr. Justice Hoffman's judgment first expressed, you've got to have extreme urgency or a risk of somehow the defendants, if they found out about it, taking steps to frustrate the order. Now, none of that was addressed. So it was never explained at any point why the non-compete or the confidentiality provisions met those hurdles. And can I make good that submission by showing you the evidence?
How much credit does one have to give High Court judges for knowing that a without notice application has to be justified?
The burden, my lord, there's a high burden on the applicant to set out the proper position. And it's very difficult for a High Court judge faced with an eloquent advocate with a skeleton argument, long skeleton argument, setting out propositions of law and making submissions that are wrong, to identify the errors in that. So I'm not answering your question directly, but the burden is always a very high burden on the advocate, on the party making the application, to justify the position. Of course, every judge sitting alone in Court 37, wherever it is, on an ex parte application will know it's ex parte, and they'll know what the law is on ex parte applications, but how you apply that is a different matter.
So injunctions to enforce restrictive covenants, at least in my experience a few years ago now, a pretty common diet of King's Bench judges.
I've no idea whether Mr. Justice Constable dealt with this sort of claim often. I often do restrictive covenant cases, and I've never appeared before his lordship, I'm afraid to say. But I simply don't know the answer to that with respect to Mr. Justice Constable. But it's all but unheard of for non-compete provision to be sought on an ex parte basis. And no case was put before Mr. Justice Constable in which a non-compete provision was granted on an ex parte basis. I accept there was one found for the inter partes hearing, but that doesn't meet the point that the judge was not told that this is a very unusual sort of order, and our evidence doesn't address the key reasons as to why this order is being made. So I don't quite know how to answer your lordship's question as to what a judge should know, but I know what a judge should be told, and that's what all the cases talk about, my lord.
Well, I know when I was doing without notice things, there were some things I wouldn't have found particularly helpful for counsel to tell me, because they were pretty obvious and the regular diet of every judge in that court. But anyway, maybe that's as far as we can take that.
So what you seem to be submitting, it's not so much that he didn't tell him what the law was. He did tell him what the law was. He set out the part CPR 24. The witness did actually comply with that. He gave a reason, but you say it was not a good reason. And you're saying the problem here was that in this field, simply to say that without counsel drawing attention to the fact that the application he was making was unusual or different, it's that's the problem.
It's more than that.
Oh.
Counsel should have told the judge that the evidence didn't meet the test he was setting out. Counsel should also have told the judge that the authorities he was relying on say that you should come back on an inter partes hearing in respect of restrictive covenants. So if I can show you the skeleton that Mr. Siddle relied upon.
Mr. Solomon, you wouldn't dispute, would you, that it was proper to go ex parte to seek orders for preservation of material and imaging?
As a matter of principle, I don't object to that. But in terms of what was put before the court, the whole application was undermined, my lord. So in respect of the evidence that was advanced, everything, all the preservation and imaging orders relied, for example, on the definition of confidential information, which was another failure of full and frank disclosure.
By the failure. In terms of unusual and what they were being told, it would be perfectly usual to put in a witness statement saying, he'll cover his tracks, he'll implicitly destroy evidence, and that's why we need it.
Your lordships are asking me questions as a matter of theory. As a matter of theory, you can go ex parte for anything. As a matter of, in practice, in this case, should they have gone ex parte when the evidence was misleading in the ways I'll show you, that my client, Dr. Ali, had been told weeks before this injunction that the claimants were concerned that he would be acting in competition, and that he was being suspended 3 weeks before the injunction, specifically to stop him deleting information. So in that context, when he's been told weeks before the injunction that the claimants are concerned about him deleting information, should they have gone ex parte? The answer is no. But the non-compete point and the breach of confidence point take matters to a higher level.
Yeah.
Because
I follow that, but are you saying that if Mr. Siddle had applied ex parte for preservation and imaging orders and for a return date within a matter of days on which non-compete and confidentiality injunctions could be considered inter partes, would that have constituted non-disclosure?
if the evidence had set out, for example, that the suspension letter weeks earlier had put Dr. Ali on notice of issues about deletion, which it didn't, then that might have been a legitimate application. It might have been. But the evidence was flawed in a number of respects, and the application was flawed in a number of respects. It's not simply about the non-compete order. It's also about the definition of confidential information, about the failure to properly deal with all the relevant evidence, and all the other complaints we made to the judge, which was successful before Mr. Justice Bourne, which he accepted. So there might have a different application with different evidence and different submissions might have been legitimate on an ex parte basis, my lord, in theory, but not this evidence.
We've got to draw a distinction between whether you think, or I think, or somebody else might think it was legitimate, and whether there was material non-disclosure, i.e. the judge was not in a position where he could decide whether it was legitimate. That's the key question. There is a difference between, say the judge got the law wrong, that would be a reason for overturning it, but it wouldn't be material non-disclosure. The question here is, was something said or not said that caused the judge to proceed?
Yeah. So materiality is a question for the law, and that was a question that Mr. Justice Bourne had to determine, and he did determine that. And this court can only interfere with that decision on materiality if it's bound to, because Mr. Justice Bourne made an error in that respect. And what Mr. Justice Bourne had before him was, in respect of the non-compete order being made ex parte, he had Mr. Terry's evidence, which is behind tab 14, and it's paragraph 116 and 117. This is where the evidence upon which the claimants relied to go without notice. And 116 is about preservation, and he concludes that without the order, if notice was given, I consider there's a real risk he would delete evidence in the meantime. And I'll make submissions to you about that in a moment when I show you the suspension letter. And at 117, he says that regarding orders sought to uphold the non-compete provisions of the SPA and the disclosure of Zettel account and linked bank statements, these will be addressed by counsel, but the court will note, one, that Dr. Ali has apparently been acting in competition with Derma Med for some considerable time. Just pausing there for a moment. If that's right, and that Dr. Ali has been acting in competition for some considerable time, that cuts against any argument that there was urgency. And then he goes on, and secondly, it's appropriate that he's held to the written agreements that he made not to do so at the earliest opportunity and before further damage is inflicted. And in respect of that, being held to written agreements, that same point could be made of any breach of contract for any
It
party.
justifies applying for an injunction, but not doing so without notice.
Exactly, my lord. It doesn't deal with the without notice points at all. So when Mr. Siddle was asked by Mr. Justice Bourne why they had gone without notice, his answer behind tab sorry, I'll just pause one moment. Um, 13, thank you. At 286, at the bottom, by G. So E to G is about the confidentiality provision, which I'll come back to. But at the bottom at G, Mr. Justice Bourne says, what about the making of without notice orders, as it were, across the board, rather than confined to preserving evidence? Mr. Siddle says, well, our submission in that regard is that despite suggestion by my learned friend, there was no evidence explaining why it was that the claimant had proceeded without notice with regards to non-compete. In our submission, that's not correct. So I can take you to Mr. Terry's statement, and he highlights the paragraph I've just read to your lordship, paragraph 117, that's it. And then he says, so the first point, where I may say respectfully take issue with my own friend, was suggesting there was no evidence addressing the question of why the non-compete was sought on a without notice basis. That shows, my lords, that Mr. Siddle got it wrong before Mr. Justice Constable.
Wrong. It wasn't a good reason. The evidence wasn't strong enough.
The evidence
But
didn't.
is it materially non-disclosed?
Yes, my lord, yes. It didn't address the tests which Mr. Siddle had set himself to surpass at all of extreme urgency or notice being given would defeat the injunction. And had he drawn those points to the court's attention, had he told Mr. Justice Constable those points, Mr. Justice Constable would never have made that order. So it was not said to Mr. Justice Constable that urgency was not addressed. On the contrary, the evidence shows, our evidence shows that Dr. Ali's been completing for some time, and it wasn't, no evidence was advanced as to why notice of the non-compete would defeat the order. Council was obliged to draw those failures to the attention of the court. And in this point is highlighted.
To what extent is materiality of non-disclosure affected by what would have happened if the defendant had been there? Because much of Mr. Grant's submissions on the facts are saying your client, your first defendant, had behaved dishonestly. There was strong evidence of that, and even if if the judge had been taken through all the correspondence and the non-payment of 633,000 and so on, even then any rational judge would have granted an injunction. That's not a conclusive reason for ignoring non-disclosure, but does it go to the issue of materiality?
My lord, no, it's wrong as a point of law, and I refer in response to that to the case in this court of appeal, of Berbahani and Salem, which is behind tab 5 of the authorities bundle. And it's a judgment of Lord Justice Wolf. Rejecting this very point. So if I can ask your lordships to go to page 99, page 729 of the transcript. E says, in deciding in a case where there's undoubtedly been non-disclosure, whether or not there should be discharge of an existing injunction and re-grant of fresh injunctions, it's most important that the court assesses the degree and extent of culpability with regard to non-disclosure and the importance and significance of the outcome of the application for an injunction of the matters which were not disclosed to the court. In this connection, Mr. Brodie, at one stage of his argument, submitted the acid test as whether or not the original judge who granted the injunction ex parte would have been likely to arrive at a different conclusion if material matters had been before him. That's Mr. Grant's submission to your lordships. I don't regard that as being the acid test. Indeed, although I regard it as a relevant matter when considering the question of discharge and re-grant of injunctions, I do not regard it as a matter of great significance unless the facts which were not disclosed would have resulted in refusal of an injunction. So in answer to your lordship's question, is it material? No, it's not a matter of great significance, as Lord Justice Wolf said. And in any event, on these facts, the breaches in respect of the confidentiality injunction that was sought ex parte meant that that injunction would never have been granted inter partes, and that's why Mr. Siddle had nothing to say in opposition to my submissions on confidentiality. It was unarguable, his position was unarguable, so the confidentiality injunction would never have been granted inter partes, and that injunction infected almost all of the orders made by Mr. Justice Constable.
You mean the confidentiality injunction in those terms, or?
In those terms, yes. It infected almost all the orders made by Mr. Justice Constable, save for the non-compete, because the definition was relied upon. So,
But an injunction in more tightly drawn terms in relation to confidentiality would certainly have been granted.
well,
inter partes,
perhaps.
wouldn't it? You never challenged that. You offered undertakings.
Well, we said we would give undertakings in respect of a more tightly drawn injunction, tightly drawn order, but that's, we say, never been provided. So your lordship.
But the only submission you can make about what would have happened inter partes is that it would not have been granted in those terms.
Yes. But that's not an insignificant submission with respect, my lord. On an ex parte application, the applicant has a high duty to put the case fairly, and here they completely failed on almost all aspects of the order. And so simply by saying, had we applied for a different order on an inter partes basis, we probably would have got it. That's not enough.
What does Lord Justice Wolfe actually mean in that last sentence that you cited to us on page 729 of the judgment? I regard it as a relevant matter, i.e. whether it would have been likely to reach a different conclusion when considering discharge and regrant. But I don't regard it as a matter of great significance unless the facts not disclosed would have resulted in the refusal of an injunction. Well, if the facts not disclosed would have resulted in the refusal of an injunction, there can't be any question of regrant anyway, so I don't quite understand that.
So I think what his far be it from me to attempt to interpret Lord Justice Wolfe to your lordship, but what I think he's saying is that it's not a relevant matter. So
No, he says it is a relevant matter.
it's not a matter of so what the submission that was made is that none of the failures of full and frank disclosure matter because had we come back into partes, we'd have got the injunction. And Lord Justice Wolfe says, I don't regard that as a relevant matter. It's only relevant to the question of regrant, not to the question of whether or not there's a material non-disclosure. But of course, if the facts not disclosed would have meant that the injunction would never have been granted in the first place, that is a matter of significance.
Well, of course, it would be decisive.
Yes.
I mean,
and that's what
speaking for myself,
I
of the two highlighted paragraphs on Bekwahani and Salem, the first one is pretty obvious, I think. The second one is less easy to understand. Do you have any quarrel with the first paragraph?
No, I'm relying on it.
Mm.
Well, the point I take from the second paragraph at F is that the submission that we would have got the injunctions had we gone into partes isn't.
That's not the acid test.
It's not the acid test, and that's because there are a different series of obligations on a party going ex parte, and when an order is discharged because of material non-disclosure, it's for penal reasons as well. And so it's not enough to say, it doesn't matter if I go ex parte because I could have come back into partes and got it. Because there's a penal aspect to discharge. And you've got a high obligation to get it right first time round. That's what all the cases say, my lord. I mean, that's a deprecating way of saying it, but it's a fundamental point of justice that both parties have access to the courts, and one party isn't able to make submissions to a judge on their own in secret, which are wrong.
So we've gone over this, but when you say wrong, I mean, what they were saying, it wasn't urgency, it was frustrate the order. That's what they were saying. And you can see it in the skeleton argument. And the witness had got it in his head that this chap wasn't complying with the written agreement and he should, and he'd cover his tracks. Now, if you stop and think about it, hang on, is that right? That might be right for destroying information or hiding information. Is it really right? How's he going to hide his tracks for
Competing.
competing? And it might be mistaken, and when you look at it in the co-light of day, you might think, no, hold on, you're failing to distinguish here between hiding your tracks and competing. And that's why I was putting to you, it wasn't so much that they failed to draw the attention of the judge to the practice direction or failed to have evidence. It's simply that when you test the evidence, it's not good enough. Not because it doesn't go to urgency, but because it's not good enough to prevent the frustration of that part of the order dealing with non-competition.
Well, I agree with that, my lord. But the submission that my learned friend Mr. Siddle made, that we've met the tests, we've overcome the hurdles that I accept we've got to overcome, was wrong in the context of the evidence he was relying on. The paragraph 117 of Mr. Terry's witness statement, which he relied upon to justify going ex parte for the non-compete order, simply doesn't address the right questions. And there's nothing in that paragraph which explains why it was necessary to go ex parte. And the point, my lord, is highlighted, if I may, by the quotation partial quotation from Briley and Bloch. So the simplest place to see it might be in my skeleton argument, because in our skeleton argument I highlighted what was left off. And it's paragraph 27, page 9 of our skeleton. I've taken mine
Your
out
skeleton below or your skeleton here?
in before your lordships.
Yeah.
So we have set out the whole paragraph of Briley and Bloch, and we've put in bold the bit which was not quoted. And so leading counsel below had quoted up to the bit in not in bold, so you could come back on with notice application for delivery up of confidential proprietary documents. And he didn't quote and interim enforcement of restricted covenants. And there's no explanation as to why that was chopped off. Must have read it. He must have read it and made a deliberate decision not to quote that bit, notwithstanding that this was an application in respect of restricted covenants. And had he put that before the court, and had he said, this is what the leading textbook says about the approach to be adopted. He was advocating that approach in his skeleton argument. This is the approach to be adopted. I'm not adopting this approach. I'm adopting a different approach. And explain why, then that would be very different. But stopping the quotation there was misleading. Why, I ask, was that omitted? Well, we've never found out. There's been no explanation. Even today, you've heard no explanation. It's obviously relevant, and had Mr. Justice Constable been told this is a highly unusual application, and notwithstanding the leading textbook suggesting that you come back on notice for enforcement of covenants, we're not doing that, then Mr. Justice Constable would necessarily have asked why. What is it that makes it necessary to enforce the non-compete now, ex parte? And we know what the answer is because Mr. Siddle gave that answer to Mr. Justice Bourne, and that is an unsatisfactory answer. My Lord Justice Lewis and I have discussed the effect of that, and maybe I'm not agreeing with my Lord about the effect, but that is the extent of it. And my submission is that no judge ever would have made that order had this application properly been made.
You would submit, I think, that it's actually a bit worse than you've said, and you've been too diplomatic, because not only does he stop the quotation before interim enforcement, he then quotes bits after it.
Yeah, he does.
So
That's exactly right.
You've been, like your friend, your colleague, far too kind.
I'm often accused of being too gentle as an advocate, my Lord, and I accept that as a legitimate criticism.
But he's taking it out, he hasn't stopped.
And he's not afraid to quote at length. There are whole pages of authorities quoted. Rather, we might find strange in the skeleton argument, but not that bit. And he didn't put any case before Mr. Justice Constable where without notice order was made. Yeah. He didn't tell the judge that it's very unusual, and he didn't draw the judge's attention to the fact that his own client's evidence didn't meet the test that he had set. My learned friend has referred to the Deputy Judge's decision in UK Power Reserve and Reed at first instance, where an ex parte non-compete was granted. But that wasn't put before Mr. Justice Constable, and the facts are different. The arguments are different, but it doesn't mean that this is a legitimate position for the claimants to have adopted in this case. In fact, UK Power Reserve and Reed was argued before Mr. Justice Bourne, and in that case, there was a regrant of the injunction, notwithstanding that it was discharged. So obviously Mr. Justice Bourne knew what the jurisdiction was because it was all set out in that case. What my learned friends say is that there was no failure here because Mr. Justice Constable was aware that he was granting without notice relief, but that's true for every ex parte application, and it would be an answer to every single allegation of material non-disclosure. Secondly, he said the claimant set out the relevant test of the grant of without notice relief, But for all the reasons I've already said, Mr. Justice Constable, I say, was misled as both as to the facts meeting those tests and as to the law in respect of how it was quoted before him. And it said there was some attempt to justify relief made by Mr. Terry. Well, I've made submissions on that. And what Mr. Justice Bourne says in his in the judge's paragraph 18 is that no good reason has been identified for seeking these orders without notice. And that, my submission, must be right. And at paragraph 19, Core Bundle, tab 6, page 58, he goes on to deal with the problem about Brearley and Bloch, and he says correctly at the bottom of page 58, if that paragraph had been read out in full, would have alerted the judge to a lack of any reason to order the enforcement of restricted covenants in this case without notice. The simple fact is the judge was not so alerted and there was no good reason. That is obviously right. It can't possibly be impeached now. And my learned friend now and Mr. Siddle below said there's no rule of law that you have to go into partes to enforce restrictive covenants, but that, with respect, is not the point. There is a textbook which suggests you go into partes, and it's a very unusual application to make, and those are the submissions which should have been made.
Can you just remind me, sorry, where the quote, the partial quote from?
Yes, it's paragraph 16 of Mr. Siddle's skeleton argument below, which is at
Tab 2, page 33.
I see.
thank you. Yeah.
The italicised words at the end come from further on in the paragraph.
Yes. Yeah. Further on in the skeleton argument. Yeah.
I wonder if I could clarify it. My note of his submission is that the quotation at para 27 of his skeleton was in there, but Mr. Siddle missed out intentionally the last 5 words, and I'm struggling to find that. So just so I could understand the submission, I don't know where that is in Mr. Siddle's skeleton argument, because I can't see it.
Well, I don't. It's not paragraph 27. It's paragraph 16.
It's 27 of my note for the skeleton argument, which he took you to. Mr. Siddle quoted Brearley and Bloch, and he says in his paragraph 16, at 1434, Brearley and Bloch gives the example of issuing without notice confidentiality injunction, an injunction restraining destruction of confidential information, followed by an on-notice application for delivery up and destruction as a more proportionate and reasonable way to proceed. And if you look at Brearley and Bloch, which is the last tab in the authorities bundle, tab 35, page 934 to 935 is the bit that's being quoted, or bit that's being referred to. I've quoted it in full in my skeleton argument, and the bottom line of 934, bottom 2 lines, followed up by a with notice application for delivery up of confidential proprietary documents and interim enforcement of restrictive covenants, was not quoted.
But then he goes and quotes the bit on the next page.
Yes.
He gives one example, he doesn't give the next example, and others he just stopped, because he then goes on and he quotes the bits from the last but one line. In
Exactly.
more proportionate and reasonable way.
Exactly.
That's your submission.
Exactly. So he's obviously read it. He'd obviously read the whole paragraph and made the decision, for whatever reason, to omit that element. And is that the way, I ask rhetorically, to conduct an ex parte application when one part of your application is to enforce restrictive covenants? Should you miss out the bit where the leading textbook which you're relying on says, come back into partes for the restrictive covenant element? Or is that misleading the court?
What about paragraph 71 of the skeleton, where it is expressly accepted that a without notice order is not the norm? And then he goes on to make a submission, which might be right or wrong, but it's justified in this case.
I think he's talking generally there about without notice applications. He's talking generally about without notice being not the norm, rather than about this specific.
No, at 70 he says this order, and then at 71 he says it's accepted that such an order, i.e. such an order as the one in this case, is not the norm. But he obviously believes that because of the evidence they've now got about D1 and his willingness to do later.
Yeah.
Okay.
Oh, yeah. He's talking.
It's merited and furthers the overriding objection. You say, well, you shouldn't have done that without saying to the judge, that's not what normally happens.
Yes. In fact, if your lordship goes back, if your lordship goes back to page 56, the internal page 36, you can see at the top of the page there, F. He's talking about the preservation orders. So paragraph 71 is about the preservation orders. And then paragraph 72 on page 58 is about the imaging, and he deals with each of the orders in turn.
The preservation order is the norm without notice.
Yes.
Well, no doubt my learned friend will explain. I suspect he's talking about going ex parte full stop. Well, but who knows? But
maybe they may just not have separated out in their own mind the difference between those parts of the application that are preservation and those parts that were non-compete. But that's your point, and that's what Mr. Justice Bourne said.
Yes.
You should
Yes.
draw the distinction.
Yes, that's right. But also, Mr. Justice Constable, in discussion with Mr. Siddle, said, "I'm not convinced that all this needs to be done ex parte.
Yeah.
So we'll break up the order into different bits. So they will come back in respect of some elements of it. And what counsel should have said there is there are different types of orders we're seeking, and some of these can be hived off for inter partes and some can be ex parte, but he didn't. So
I'm not suggesting this about Mr. Siddle, let anyone think about it. But in the unlikely event, you have counsel who's less than competent. And I'm not saying this about anyone here or Mr. Siddle. And he gets it wrong. Is that material non-disclosure, or you just have to go through the routine of getting an appeal, having the order overturned because the judge wasn't helped,
yeah,
and doing them for costs?
I'm afraid it is material non-disclosure. It does. The court does not look at the reason for the errors, and you'll never know. You don't know what a counsel would have advised or said behind the scenes. Actually, there's an obligation on counsel to present the case fairly, no matter what he or she is advised.
But competence.
Exactly. But a party is bound by their counsel and by the submissions they make. Unfortunately for my clients, they're bound by me. But the court should not be looking behind counsel to assess competence. And this is the claimants are taken to have advanced this position. And in fairness to Mr. Siddle, even after receipt of my skeleton argument, where my learned friend wrongly says these points were taken for the first time, even after that, the claimants continued to pursue their position, and their first position was all of the relief we're seeking should be continued. So obviously that was their position. Now I know at the time I've only dealt with one of the grounds, so I'm going to deal with matters relatively speedily if I may.
Yes. Do carry on, Mr.
Just dealing with tying up a couple of points. I referred in my skeleton to the submission that my learned friend made about it is all technical. We could have come back into parties and got all these orders. My paragraph 32, and we say for the reasons there, it's wrong as a matter of law, but actually as a matter of fact, they wouldn't have got it into parties anyway. And secondly, at paragraph 33, we refer to the submissions that my learned friends make about my clients not having suffered any particular hardship. These are wrong. That isn't the right test, and in any event, they have. So drawing strands together on this point, we say this is a significant and culpable failure, and it's not a technical near miss. And my learned friend keeps saying it wasn't cavalier or high-handed, but we respectfully disagree. Secondly, as to the suspension letter, and this is related to the non-compete submissions I've just made, because the suspension letter set out in terms that my client, Dr. Ali, was being suspended in part because he was setting up competing business. Mr. Justice Bourne dealt with the suspension letter at his paragraph 20, tab 6 to 4 bundle, page 59. His Lordship says, the judge should have been shown the letter of 31st of May telling Dr. Ali the claimants wished to investigate allegations he had taken cash payments, not properly responded to sales leads, failed to keep proper clinical records and ignored a client complaint, and being disloyal by slitting other senior employees to leave the business. That too would have led the judge to ask why it was thought necessary to restrain competition without notice, and that's plainly correct. The letter itself is behind tab 42 of the supplemental bundle. Your Lordship have been taken to it, although only bits of it were read out for whatever reason, and perhaps the most important bits weren't read out by my learned friend. So it's tab 42 supplemental bundle, and it's difficult to see, but I think it's page 663. The first paragraph says, as was explained to you, the board's taken the decision to suspend you with immediate effect under clause 23.1. That refers to gross misconduct. I can give you the references to the service agreement if your Lordship's needed. And reasons to allow an investigation. The allegations subject of the investigation.
The Honourable investigators into your conduct, grounds to consider that you may have potentially seriously breached a number of the provisions of the service agreement and or financial duties as a director. So you've been told of that as well, you would submit.
Yes, very serious allegations being made to him. And then they're set out, they're particularised in a bit more detail. My learned friend says only bullet point 1 is relevant. He's plainly wrong. You've taken cash payments for treatments provided to clients and or encouraged or permitted other employees to accept cash payments. So this is part of the ex parte application dealt in terms with cash payments being taken by my client. Why was that ex parte when my client has been told of that allegation 3 weeks before the application? You failed properly to respond to sales leads and or pass them on to the company. And what's that about? That is about diverting sales from the company, i.e. competing. You failed properly, I was about to not split an infinitive by this quotation. You failed to properly keep clinical records of treatments and ignored a client complaint. And lastly, you've been disloyal in suggesting to senior employees they should leave the company, and this wasn't read out by my learned friend, to work with you at a competing business. So it's obviously relevant to the application, an ex parte application to prevent competition, when he's been told 3 weeks before, over 3 weeks before the application, that we're suspending you because we think you're competing with us. And then it goes on. Company reserves the right to change or add, depending on the evidence. The reason for suspension is to preserve the integrity of the investigation, that employees are not unduly influenced, and documents aren't deleted. So there was a fear stated to my client that he's got to be taken away from the premises, got to be suspended, because otherwise he'll be deleting documents. And over the page, paragraph 7, he's told he should not delete, tamper with, or alter any relevant document. So he's told about not deleting things. He's told about their concerns that he's not competing, and he's told about their concerns that they have about him deleting documents. Weeks before the application, can I just very, very quickly show your Lordships the context to this suspension letter? I'm not going to read all the documents, I'm just going to show you the fact of them. At tab 36 in the same bundle, at the bottom email, page 642, on the 3rd of April, Dr. Ali demanded the payment of 633,000. At tab 37, page 644, Mr. Terry, who wrote the affidavit himself, says on the 4th of April, we acknowledge your request, must inform you we intend to set off all or part of the claim against you. We'll be making once PwC provides completion accounts. And then tab 38, and tab 37, by the way, wasn't surprisingly in Mr. Terry's affidavit, not in the evidence before Mr. Justice Constable. Tab 38, on the 5th of April, those instructing me, Dr. Ali's solicitors, drew Peel Athena's attention to the no set-off clause. You can see page 646, paragraph 7, that was set out in terms. And then tab 39, on the 13th of April, this is the letter, again, not referred to by Mr. Terry, not shown to Mr. Justice Constable, where Loch Lord say two things. The first paragraph wasn't read out to your lordships by my learned friend. They say, we instructed that the company is in urgent need of a short-term cash injection. And that shows that the company is in dire financial straits, and that goes to the cross-undertaking and damages that the company gave. But this wasn't shown to the judge. And secondly, there's no dispute that the conditions in respect to the earn-out have been met. So they're not disputing it. And then tab 41, the letter before claim from those instructing me, this was shown to Mr. Justice Constable, but only I think he was shown in particular paragraph 38, where it was said there was a vendetta against my clients, but that's in the context of threats or derogatory comments by the claimants. And it wasn't taken through the letter and shown in terms that Dr. Ali was saying he's owed significant amounts of money because of the earn-out and the no set-off provision. And it's in that context, a few days later, 2 clear days later, that tab 42, the suspension letter, was sent. So they've received a letter before claim, and their immediate response is to suspend him. Obviously, put in that context, it looks very different. And then 43 is Dr. Ali's resignation, and 44. 44 is a document that was shown to your lordship about repudiation, and my Lord Justice Lewis talked about the fact that repudiatory breach of the employment contracts flagged up, and my learned friend said that's just about the service agreement, not under the SPA. But if your lordship looks at paragraph 4, it said the suspension letter didn't fully and properly detail the alleged misconduct, i.e. Peel seems to have a vendetta against our clients and is trying to use whatever means to get out of paying various sums due to them pursuant to the SPA and drive them out of Derma Med. So it's in that context that he's saying there's a repudiatory breach of the employment contract, but plainly there is an argument, at least, that they are in repudiatory breach of the SPA. And that point wasn't flagged up to Mr. Justice Constable at all. He wasn't alerted to that. And then at tab 45, 13th of June, the letter seeking undertakings from my client by the claimants. You've been shown Mr. Terry's witness statement, And it was said by my learned friend that that makes it clear that Dr. Ali had been suspended. And he's right in that respect. So you were shown behind tab 14, paragraph 17, page 327, where it says that Dr. Ali was suspended, but for whatever reason, Mr. Terry doesn't give the reasons for the suspension there. He doesn't set them out in the ex parte application. So all that Mr. Justice Constable knew in vague terms that there'd been a suspension, not that weeks before he'd been suspected of competing and that he'd been told not to delete evidence. So the allegations in the ex parte application were, and you can see it in Mr. Terry's evidence, paragraph 55 onwards, that he was taking cash payments, and that's stated in terms in the suspension letter, that he was competing unlawfully, again that's stated in terms in the suspension letter. He's trying to get other employees to work with him at a competing business, and that he's, a suspension letter says he's being suspended to stop and destroying documents. So the claimants asserted propositions that they needed to go ex parte in order to stop Dr. Ali destroying documents if he found out they had these suspicions, are obviously wrong, as is the suggestion of urgency, given that the suspension letter was 3 weeks earlier. And in our submission, it's plainly misleading not to have shown the court this document. And there's no explanation even now as to why that document, which is obviously important, was not put before Mr. Justice Constable. My learned friend didn't address you on that. What he said instead was, it doesn't matter because you get the same points from the other documents that were put before the judge. Now, the problem with that submission, he said this in terms, Mr. Justice Constable knew we'd written to Dr. Ali before the hearing, requiring him to cease and desist competitive activity. That's what Mr. Grant said to you. The problem with that submission, it is directly contradicted by his client's own evidence and by the submissions made by Mr. Siddle before the court. So the hearing note at supplemental bundle tab 4, tab 3, page 70, just so you're clear about this, the DWF letter referred to is at tab 44, and the Lock Lord letter referred to as at tab 45. I've just shown you those two letters. But what Mr. Siddle says at page 70, in the middle of the page, between the two hole punches, is that the DWF letter is a response to the undertakings in a different context. No undertakings were sought in respect of the items raised in this application to avoid tipping off and data deletion, which is why this application is without notice. So Mr. Siddle is saying in terms to the court, directly the opposite of what Mr. Grant has just told you, that we didn't tip off because that information isn't in these letters. Similarly, Mr. Terry's statement at tab 14, paragraph 109, at page 351, says in terms, undertakings were not sought from Dr. Ali in relation to the non-compete obligations at the risk of tipping off Dr. Ali and any possible further deletion or destruction of evidence which would have frustrated the current application. So in that context, my learned friend's submission to your lordships that Mr. Justice Constable knew we'd written to Dr. Ali before the hearing, requiring him to cease and desist competitive activity, is simply wrong. Can't be made in light of the evidence, his own client's evidence, and counsel's submissions before the court. So,
I'm not sure if I'm right, but the impression I've got is that the two letters that were shown are carefully drafted and deal with the prospect of Dr. Ali recruiting employees, i.e. the people presumably going to administer the photographs, and don't deal with the question of competition in the sense of has already been taking money from clients that should have been money allegedly that went to Derma Med. So they drew a distinction between those two things, and the suspension letter would have made a case not just getting ready to set up a business by trying to recruit trainers, it's you've been taking the money, mate.
Yeah.
Or words to that effect.
That might be right. It might be right, my lord, but what we know is that the suspension letter at tab 42 was received on the 31st of May, and the Loch Lord letter at tab 45 on the 13th of June, a couple of weeks later, and it's written in the context where the writer knows that Dr. Ali already knows of these previous allegations, and that's why at page 670, tab 45, 670, 5.1, I meant. It said, first, it's factually wrong that Dr. Ali's suspension was motivated by anything other than Derma Med's genuine concerns about Dr. Ali's conduct, as outlined in the suspension letter. So it's a reference back to that. So it doesn't repeat what it says there, but your lordship is right that it does deal with everything in a slightly different way. The clearest place where the allegations were set out was the suspension letter. And that's why it was open to Mr. Siddle and Mr. Terry to say, we didn't tip him off by any of the other documents. But what it wasn't open for them to do was to make that submission without putting the suspension letter before the court. And it's not open to my learned friend now to say the opposite, which is everyone knew what was going on. And plainly, Mr. Justice Constable didn't know that Dr. Ali had been made aware of these allegations weeks in advance. He doesn't say that. He doesn't say anything of that sort. And had he known that, it's inconceivable that he would have allowed the application to be made ex parte or granted the order like that. And even now, even in this appeal, there's no explanation as to why that obviously significant letter was not put before Mr. Justice Constable. So we say, given that letter and given the way that the case was advanced about competition generally, these are material non-disclosures. May I turn to the confidentiality obligation? Mr. Justice Bourne dealt with this at paragraph 21, core bundle, tab 6, paragraph 21, page 59. He says a further failure has been accepted by Mr. Siddle today. The definition of confidential information, which was used in all of the operative provisions of the injunction other than non-compete, is hopelessly wide. That's a quotation from Caterpillar, hopelessly wide. It used the phrase, including but not limited to, which was disapproved in Caterpillar at 68, dependent on a judgment being made as what was reasonably regarded as confidential. Pausing there for a moment, that's a question my Lord Justice Males asked in respect of the new injunction sought by the claimants. I'll come to that in a moment, but it was directly addressed below as well. Your Lordship indicated that it hadn't been addressed by us. It has been.
I indicated the judge had made 2 points, and that was one of them.
Yes. Well, forgive me if I misunderstood it. He went on, and it extended far too widely any information relating to the business and affairs of customers of Derma Med or Athena Group. There's a failure to draw the judge's attention to the unsuitability of that provision or the authorities which are relevant. Mr. Siddle has accepted he fell into error in that regard. So the my Lord Justice Males asked about maybe I can deal with this point now, asked about the terms of the confidentiality order behind tab 1 in the core bundle at page 17. And your lordship asked my learned friend about subparagraph 3, information that might reasonably be regarded as confidential, and asked how my clients are meant to know what that means. And I think I had heard, and perhaps it's my mistake, that we haven't had a chance to make, or we didn't deal with that point below. But that is a point we dealt with because it appears in the definition that's relied on below, and that's why at paragraph 21 of his judgment, Mr. Justice Bourne said, amongst other things, it, i.e. the definition that's he held to be wrong, depended on a judgment being made as to what was reasonably regarded as confidential. So I have made submissions on exactly that type of clause. For your lordship's note, my skeleton argument below is at tab 10 of the supplemental bundle, page 191, paragraph 42, where I go through in terms the errors.
Well, speaking purely for myself, it's pretty obvious to me you can't have an injunction in terms of paragraph 3.
Yes, and that's what my learned friend is relying on now as the continuation injunction. I think he's abandoned the terms of the injunction that was sought before Mr. Justice Bourne and obtained before Mr. Justice Constable, and these are the new terms that he says are fine. But it's obvious, as your lordship says, that that's not fine. In fact, there are errors throughout this clause. So for example, it said that information relating, whatever that means, what information relating to all clients, relating is a very wide word, all clients or customers of the first appellant. That's irrespective of whether my clients ever dealt with these people, and there were other doctors who were dealing with people. Client, delegate or model names, not clear why that is confidential. And then telephone number, contact details, and I'll show you in a minute Caterpillar and Capita and Darch where it says this sort of information isn't confidential. And then paragraph 2, marketing materials, whatever that is, even presumably if they're made public and sent out generally by the claimant, that is asserted to be confidential. And then the errors with paragraph 3. Now, in terms of this provision, there's no evidence as to why that confidentiality injunction is needed. No evidence as to where it came from. I can tell you how it appeared. At the hearing before Mr. Justice Bourne, I think as I was just about to start making submissions, I was handed the letter behind tab 50 of the supplemental bundle at page 696. That says, they're writing in response to my skeleton, paragraph 2, our clients will continue to seek a confidentiality injunction on the terms set out in the constable order, but paragraph 3, we'll put you on notice as a fallback argument, we'll seek an order in these terms. So there was no application made. It was just handed up to me as I got to my feet. And as you will have seen, if your lordships read the transcript, I hadn't considered it properly when I was making submissions to Mr. Justice Bourne. But it's obviously, it's not a proper confidentiality injunction. Mr. Justice Bourne was right in saying that the confidentiality injunction should be discharged. And that is because it was hopelessly wide. So if I can show you the confidentiality injunction that was obtained before or from Mr. Justice Constable, that is the supplemental bundle tab 4. This is the, if I can call it, with no disrespect to the judge, the constable order, starts at 74, and your lordships will see paragraph 4 is the non-compete injunction, paragraph 5 is the obligation to keep confidential information, and that uses confidential information in defined terms, as does paragraph 6, 7, 8 and 9. So all the operative orders other than non-compete use that definition of confidential information, and the definition can be found at page 81. And at the bottom of the page, it says all confidential or proprietary information, so pausing there for a moment, starts off as a circular definition. Confidential information means confidential information. However recorded, including but not limited to, and that is a failure that this court in Caterpillar says was meant that a definition was hopelessly wide. It doesn't end there though. Any information, so it's very wide, that would reasonably be regarded as confidential, and that has the same error that Lord Justice Mayles identified just now in the order sought to be made by my learned friend, relating to, whatever relating means, very wide there. Business is defined as the business carried on by the company, being the business of all of those things. So it's a very wide definition of business. And all those other matters, affairs, customers, clients, plans, intentions, whatever that is, and so on. And it's not simply of the company, but it's of the second applicant or the second applicant's group. And if that's not wide enough, includes any information derived from confidential information. Anything derived from confidential information, even if that isn't confidential itself, would be included in that material. There are two major problems that my learned friend faces in respect of the submission he makes that Mr. Justice Bourne got it wrong in respect of confidential information. The first is that there was a concession below that there was material non-disclosure. I'll make good that point in a moment. Secondly, even if I'm wrong about that concession, that there was material non-disclosure, there should have been a concession that there was material non-disclosure in respect to the confidential information definition, because it plainly went way too far and the court was misled at first time round. Mr. Justice Constable was misled as to whether or not that definition was supportable. So if I can make good...
There's another clause over page 82, and things that are in the public domain, for example, are not confidential information. So marketing information that is your plans when you're saying how we're going to get people into Botox is confidential, but your website saying you look as good as Lord Justice Lewis if you're Botox is in the public domain.
I accept that.
Yeah.
Apologies.
Which is covered in part. So if you took out the word reasonably regarded as confidential, any information that was confidential relating to that, would there be a problem with the first subclause? Which is just defining all confidential information about any confidential information, or any confidential information relating. I know you don't like relating, but is there any problem with it?
I apologise. Is your lordship referring to the definition in the order made by Mr. Justice Constable, the one?
No, yes, the one at 81. This is
Yes.
If you
what I don't need to do with respect is to make submissions about how this could be cut down to.
No, I understand that you don't have to, but I'm inviting you to. And if you looked at little one, it's never good to draft by committee anyway, and you objected to the words would reasonably be regarded as, and if it simply said one, because this is an inclusion, any confidential information relating to the business, and so on, given we've got the exclusion as well, and two, any confidential information. I wonder whether that wouldn't actually solve the problem, whether the problem is as big a problem as one thinks.
Well, I think if you've got to delete including but not limited to as well, you've got to delete any information that would be reasonably regarded. My submission,
yes, exactly. That's what I just done.
My submission, it goes further, that relating to goes too far. It should be specific elements that are identified. For example, client lists, or specifically obvious, precise matters that can be easily identified, because this is a contempt jurisdiction and a party must know precisely what it is they enjoin from doing or not doing. And cases like Lawrence, David and Ashton have, and all the cases since then, have repeatedly said you've got to have precision. And
do they say you can't have words like relating to, or does it just not arise in those? I mean, let's not draft.
I can't recall a case on relating to. My submission is that's obviously right, because it's not clear what relating to means.
Mr. Sullivan, am I missing something? your client had been, until quite shortly before this hearing, a director of the company. It's a sale of a business case, not an employment case. Suppose that this clause is, as you say, hopelessly wide. Doesn't a departing director have some obligations of confidentiality
Yes,
towards his former company?
yes,
So what you're saying is that although an order of some kind relating to confidentiality, relating to confidential information, could properly have been granted, you say that it shouldn't have been applied for ex parte, and the use of this poorly drafted clause in the contract constitutes material non-disclosure.
yes. I go further. Yes, those 2 points are correct, my lord. Those are my submissions, but I go further in respect to the second point, and I say that before Mr. Justice Constable, learned counsel had told the judge that there were no problems at all in the definition of confidential information. He referred in particular to paragraph 68 of Caterpillar and said none of the problems identified in that paragraph apply, and that was simply wrong. Can I show your lordship that point?
Caterpillar, I mean, that's a much more standard employment case.
But it applies to the definition of confidential information. It isn't determined on the basis that it affects an employee. Simply because the definition is in a different context doesn't mean that confidentiality should be can be defined more broadly, or can't be understood by the respondent. So if I can show your lordship, firstly, my learned friend's skeleton argument, Siddle's skeleton argument, tab 2, paragraph 47. Sorry, page 47, paragraph 50A. He says confidential information is defined in sensible and non-expansive terms. And then over the page at 51, he said, further, the limitations sought are clearly defined so avoid the uncertainty which concerned the court in Caterpillar. So this was the claimant's counsel's own submission that you need to avoid the uncertainty in Caterpillar, my lord. Caterpillar is in the authorities bundle at tab 18. And paragraph 68 is at page 449. Top of 449. This is Lord Justice Stanley Burton. I'd add that the form of interim relief sought by CLS is hopelessly wide. That's where the judge gets that phrase from. And vague. Doesn't specify the confidential information to be the subject of restriction with any certainty, but simply describes it as all or any confidential information acquired by the respondent during her employment, whatever form. The particulars do attempt to identify some of the confidential information it seeks to protect. I say some because the allegation is that the respondent had access to the identified information, in particular but not limited to the listed information. So I think significant there's no evidence the respondent's copied any of the documents referred to. So the very points that were identified by paragraph 68 are present in the definition of confidential information relied upon below. And so paragraph 51, with respect to counsel below, was unarguably wrong and misleading. And the very error found to be impermissible in Caterpillar was present in the clause. We don't, for our part, understand how that submission could have been made. It's plainly wrong. And Mr. Siddle repeated this point orally behind tab 3, page 68 of the bundle. So top of the page, Siddle's submission is, before Mr. Justice Constable, it's important to look at the SPA. The definitions of confidential information and non-compete, read out page 85, which deals with confidential information. These are tightly focused definitions. They don't capture, for example, if Derma Med diversifies into IT comms, which I'm not saying it did. Clause 12.4 contains exemptions. There is a tight and careful definition of confidential information. It doesn't go too far by saying general skill and knowledge. At least at the interim stage, it's a sensible and tight definition of any kinds of information reasonably regarded as confidential. Mr. Siddle also referred in his skeleton argument to the case of Capita. Can I ask your lordships to look at that in the authorities bundle, which is at tab 25. And if I can ask your lordships to look at page 662, paragraph 83. That case, which was before the court and had been relied upon by the claimant's counsel as supporting his application, at paragraph 83, this paragraph wasn't referred to the court, and there are a number of points made in this paragraph which undermine the...
So sorry, which page?
It's page 662, my lord, it's my fault, paragraph 83, tab 25 of the authorities bundle. So there the judge is saying that the definition doesn't have a remotely acceptable degree of precision. Among other things, it suffers from the vice identified by Lord Justice Stanley Burton of incorporating expressions such as including but not limited to and other similar information. It seeks to protect information regarding telephone numbers of clients, which I doubt can be properly claimed as confidential information. C extends to similar information relating not only to the claimants but any group company. And D also extends to any information which the claimants or any group company claims over duty of confidentiality to a third party, the ambit of which the defendants are likely to find it impossible to know. So many of the problems with definitions of confidential information identified by the judge there apply in this case, and none of that was drawn to the judge's attention. So all of that is a failure, we say, of full and frank disclosure. And notwithstanding my learned friend's submissions, it was immediately obvious to us on this side that the court had been misled on the definition of confidentiality, and the point was referred to expressly in Dr. Ali's witness statement. My learned friend has referred you to that. I can just show you briefly. His statement is behind tab 18. If I can ask you to look at page 385. Paragraph 7.8, supplemental bundle, tab 18. Paragraph 7.8, Dr. Ali saying, I'm willing to give confidentiality undertakings limited to truly confidential information and inform where the information is determined with precision so that I know exactly what I have to do. Currently, however, I do not know what the precise extent of the order is, given that the definition is expressed to be non-exhaustive and is in generic terms. So it's obvious that Dr. Ali was saying the definition is impermissible there. He also says at page 427, paragraph 88, that he doesn't accept the definition of confidential information as set out in the order, which is vague and non-exhaustive. Willing to give confidentiality undertakings if required, but limited to truly confidential information and in a form where the information is determined with precision. So I know exactly what I have to do. It can't possibly be said. This was sent on the 18th of July along with our application to set aside the order of Mr. Justice Constable. Mr. Justice Bourne held that that was made promptly, and that was months before the October hearing before Mr. Justice Bourne. And what my learned friend says now is that no one on our side, hadn't occurred to anyone on our side that there was any problem with the confidentiality definition. That's simply wrong. I accept that no one on the claimant's side appeared to understand the problems until I had set it out in terms before Mr. Justice Bourne. Indeed, even after our skeleton argument had been submitted, which set out in detail all these problems, the claimants put in a further statement, for your note, tab 19, from someone called Ms. Fry, seeking continuation of the confidentiality injunction, and that letter on the very day of the hearing seeking continuation of the confidentiality injunction. But it wasn't until I had made submissions that this point was conceded by counsel. Now, in respect of that concession, I'll be very brief on this.
Why did DWF not follow up as they said they would at paragraph 89? That's what you would expect to happen, isn't it, if someone's offering undertakings?
DWF didn't promise to set out terms of confidentiality undertakings. They said they would write to Lord about it. Now, I don't know what all the correspondence said. I accept that those instructing me did not write setting out the terms of an order, but it's for the claimant to define the terms of the order. And even now, they haven't defined the terms of the order. But the starting point, my lord, is that what we applied to do was to set aside the order made ex parte for a failure of full and frank disclosure, and there had plainly been a failure of full and frank disclosure in respect to the confidentiality obligation. And Mr. Justice Bourne, notwithstanding that Dr. Ali had offered to give undertakings, and that offer was repeated by me in my skeleton argument, didn't require undertakings from us in the context of the hearing. But can I briefly show your lordship what was said to Mr. Justice Bourne and what Mr. Siddle conceded? So behind tab 13 is the transcript, and your lordships will see that at 260 so 259 at the bottom of that page, I'm saying that the form of the order was hopelessly wide and vague and wide. At 260 I refer to Lawrence David and Ashton and Capita and Darch and the Caterpillar judgment. And then over at 261 I say B, so in the skeleton argument for the ex parte hearing, what's perhaps most surprising is these cases are referred to, but these points were not drawn to the court's attention. And then I refer to the relevant paragraphs dealing with Caterpillar, which I've shown your lordships. This is simply wrong, so wrong as to be misleading. And I refer to Caterpillar as well, and say that the claimants rely on Capita, I beg your pardon, for a completely different basis, and that basis is wrong. And then at the end, at E, I say, what's surprising about the approach is not only was that wrong and misleading as a submission, but the court wasn't taken to the key bit of Capita and Darch, where the very basis of the confidentiality application was undermined. No doubt that will be explained to you by my learned friend. Then I go on talking about how matters were made worse. So I put it very high. I had said in terms that the submission before Mr. Justice Constable was wrong and misleading. And that is the context in which Mr. Siddle responded. Mr. Siddle, the only thing that he said about confidentiality in the whole day hearing was at page 286 between E and G. That is the totality of the submissions. So Mr. Justice Bourne says, looking back at this stage, do you accept any shortfall, if I can put it in that way, the assistance given to the judge? Yes, I have to accept in the context of the confidentiality injunction I fell into error. On the definition of confidentiality, on the definition, must accept I fell into error. So we don't need to labour that point. We do not. And then it goes on about what about orders across the board, and I've read out further elements of that already to you. So that's the extent of what was accepted. What I had submitted and what seemed to be, and in respect of which there was no dispute, was that Mr. Siddle was wrong and misleading before Mr. Justice Constable. My reply at page 316, perhaps I can ask your lordships to read between A and E on 316. So my submission there, my lords, was that Mr. Siddle had accepted that there was material non-disclosure. Mr. Siddle was sitting next to me, and if I'd got that wrong, no doubt he would have stood up and said, that's not what I accept. I accept something much more limited in the way that my learned friend now says was conceded below. And furthermore, the judgment sets out, and the judgment was read out loud as well, extempore, sets out that Mr. Siddle accepted he fell into error and this was a failure, i.e. a failure of full and frank disclosure. So plainly Mr. Justice Bourne understood, as I did, that there'd been a concession below, that there was a failure of full and frank disclosure in respect to the confidentiality obligation. My learned friends now say they don't accept material non-disclosure, paragraph 62 of their skeleton argument. That's wrong. It's what I understood and what the court understood, and given what Mr. Siddle accepted in the context of what I said, it's plainly what Mr. Siddle was saying as well. And Mr. Siddle allowed the court to proceed on that basis. So there are two major problems with my learned friend's submissions in respect of the confidentiality element of the injunction that was obtained ex parte. One is that there was a concession that hasn't been withdrawn, and there's been no application before your lordships now to withdraw a concession. And two, it's obviously wrong in any event. The concession was rightly given because all the submissions made by Mr. Siddle were misleading in respect of confidential information. So these were fundamental failures, we say, to accurately describe the court or bring to the court's attention the fact that the injunction should not be made in those terms. And what the appellants seek to do now is downplay the significance of these failings. They say that they make all the points they make, in fact, they're not entitled to take because they weren't taken below. You've seen the extent of the submissions below. So all these points are new points on appeal, which they shouldn't be allowed to take at all. But what they say is that first, the definition matched the definition in the SPA, and that's irrelevant because in almost all cases, parties are relying on contractual definitions. And the real question is does the assertion of confidentiality amount to what is confidential as a matter of law? Secondly, they said that because Mr. Justice Constable granted the injunction, he knew what he was doing. But with great respect, he only granted the injunction because he was misled, we say. My learned friends rely on my client's willingness to enter into ADR and allow the injunction to remain in place for a while. Well, that shouldn't be held against him. He applied promptly, and Mr. Justice Bourne held he applied promptly and flagged this point up. And allied to that is my learned friend's suggestion that no one on our side had seen this point. But that's obviously wrong when you look at the skeleton argument. Look at, I beg your pardon, the witness statement, where this point is set out in the witness statement. Now, the rules on witness evidence, as this court will know, are that you shouldn't be making submissions in witness statements. And so it would have been wrong for us to explain in the witness statement why, as a matter of law, the points that Dr. Ali made meant that the definition was wrong. But in any event, none of that changes the
Well, you needed to say it in your application notice, and you didn't. What were the grounds of seeking to set it aside? All you said was non-disclosure, but you didn't tell them what it was that they had not disclosed. How are they supposed to prepare to deal with that?
With respect, my lord, that point has never been suggested, that the respondent, the appellants, claimants, have never said that we weren't able to deal with this point because it was the law on this was only fleshed out in your skeleton argument, notwithstanding that the point was fairly and squarely in the witness statement. The key issue is this.
Maybe so, but it's a big problem in these non-disclosure cases because what happens is that the claimants find they're shooting at what tends to be a moving target, unless a defendant does pin their colours to a mast at some early point.
But that might be right in general. But in this case, this is a straightforward point. It's so obvious that everyone, any barrister advancing these propositions should have known it's wrong. And
So obvious that any judge should have known then.
well, perhaps Mr. Justice Constable fell into error, but he was misled. Mr. Justice Bourne didn't. But none of these points was taken by Mr. Siddle below. Mr. Siddle didn't say, I can't deal with this point now because I've only had the skeleton argument for a few days before the hearing, so I'm unable to deal with it. He just conceded it. The point on appeal is not that we failed to set it out properly, and so we shouldn't have been allowed to take this point at all. That's not an appeal point. In fairness to my learned friend, that's not a point he takes. It's so obviously wrong that it shouldn't have been advanced in this way. And this isn't, not contrary to my learned friend's submission, a minor or technical breach, and contrary to my learned friend's definition, it doesn't only go to one aspect of the relief. As I've shown your lordship, it goes to the whole suite of relief. Now, in respect of the imaging orders, it undermines that as well. But as a matter of practicality, when Mr. Justice Bourne was asking at the end of the hearing what should happen in respect of that, we just, as a matter of simple pragmatism, did not say all the images should be destroyed because the definition is flawed. We pragmatically went along with it. But that doesn't mean that the claimants were successful in that respect. Actually, those, on an inter partes basis, that order would never have been made because the definition would have undermined it. A different order might have been with different submissions and different terminology and different evidence, but that isn't the position we're in now. So for all those reasons, we say that's another failure of material non-disclosure. If I can move, and I'll try and do this as quickly as possible, as I note the time. I'm not sure when my guillotine comes down, but no doubt my learned friend will want to reply. Sorry, I didn't mean to interrupt your lordship.
Well, quite. No,
I'll try.
you completed the sentence for me.
That's a great praise from my lord for my advocacy skills.
Yeah.
On the fourth point, repudiatory breach of the SPA, the four elements identified by my Lord Justice Mayles are absolutely right. The claimants had failed to pay, which was accepted by them. There was a no set-off clause. There was arguably no defence, and they had advanced no reason other than set-off for not paying. And those points weren't set out to Mr. Justice Constable. And had they been, there were a whole series of issues which would have had to have been addressed. Like, for example, whether or not they're in repudiatory breach, and whether or not that repudiatory breach could be accepted by my clients, and if it was accepted, what would happen to the contractual relief they were seeking, whether or not a party in repudiatory breach, or arguably in repudiatory breach, should be entitled to equitable relief, and in respect to the cross undertaking, a party who is unable to pay what it contractually owes, is that party able to give a cross undertaking? But none of this was advanced. All of this should properly have been advanced before the judge. My learned friend mischaracterises our case as suggesting that the claimants failed to concede that they had no defence. That is not our case. Our case is they failed properly to set out the full position before the court. All the points my Lord Justice Mayles made. And so
was it material for the judge on an injunction application to know any more than that there was, as there always is in this type of case, a dispute as to whether this was a constructive dismissal case? There's a tribal issue as to whether the claimants had repudiated. Nobody was in a position to, as it were, give summary judgment either way, were they?
Well, that's our respondent's notice. I'll see if I can persuade your lordship to a contrary position. But what the judge should have been told is that this was an issue. Those 4 points that Lord Justice Mayles identified were all relevant and material.
If he had been told, he would have said, "Oh gosh, that's difficult. There's a serious tribal issue." And
well, the question of what difference it would have made isn't, with respect, the right question.
no, I understand that. I do understand that I must first decide whether there's material, well, whether there's non-disclosure and whether it's material. But the next questions I will have to decide is, because it's one of the factors in Lord Justice Wolf's judgment, is the relevance of the outcome, the relevance to the outcome.
So, with respect, the first question is not whether it's material, but whether Mr. Justice Bourne erred when he conceded it was material. So it's actually a much higher hurdle that appellants have to overcome.
Yeah, I got that, yeah.
And so for all the reasons that we've set out in our skeleton argument between 52 to 58, we say it was material.
But Mr. Justice Bourne did actually think there was a serious issue to be tried, because when he came back to regranting, he said there was, and that must have included the things about which he then knew.
On repudiatory breach, he said there was a serious issue to be tried. But that doesn't deal with the point that none of this was advanced at all before Mr. Justice Constable.
You know, I understand that, but you reminded me that it was right that I got to look at what Mr. Justice Bourne thought about it, and he certainly thought there was non-disclosure and that it was material. But by definition, he cannot have thought it would have affected the outcome, because he still said it was a serious tribal issue.
Well,
serious issue to be tried.
It wouldn't have affected the outcome as regards enforcement of the non-compete restriction, but it might have affected the willingness or otherwise of Mr. Justice Constable, for example, to accept a cross undertaking from the claimants when they're unable to pay their debts. So it might have done, and whether or not it's a material, whether or not it would have made any difference is a slightly different question. And my learned friend dismisses all this as a technical breach.
No, I understand the different questions, but I was focusing on only one of the 33 questions. But I haven't forgotten the others, I promise you. Yeah.
So the judge wasn't shown the letter which I showed your lordships at tab 39, where the claimants accept not only that they are cash strapped, but they accept that the conditions in respect of the earn out have been met. So they say, yeah, we owe you the money, we're not paying you because we've got no cash. And nor was the judge shown the clause 11 of the SPA, which contained clear provisions on the ability or otherwise of the claimants to set off amount, and we say it's a clear no set off clause. And nor were they shown that the claimants had advanced no argument explaining why that didn't apply. So we say it was incumbent upon the claimants to explain to the court that they accepted they owed the defendant money, and it wasn't simply that there was a dispute as to who owes people what. They had accepted that. My learned friend says, but that isn't an irrevocable acceptance. That may or may not be right, but it's a very damaging point if a party accepts in correspondence that the conditions for payment have been met. And one would think they have to highlight that to the judge and highlight that the only defence that on which they placed reliance appeared to be barred on the face of the contract. And we say, for the reason, I'm not going to go through it, but for the reasons we set out in paragraph 56, that the arguments advanced by the claimants are fanciful as to why the no set-off clause wouldn't bite. So very briefly, they say we could have got a counsel's opinion to show that that was owed, but they hadn't, and so that element doesn't apply. And they say the no set-off clause doesn't apply to other claims we've got, but it does apply to all claims under the contract. So it does apply to the element of the withheld amount that we were claiming. So it's not a strange or exotic suggestion to make that my clients would consider they were in that the claimants were in repudiatory breach, especially since they said that in terms in respect of the service agreement after the sentence after they referred to non-payment under the SPA. So we say all of that should have been referred to. On the cross undertaking as to damages, I will be brief on this. It's plainly a matter that was before the court. I had made submissions in my skeleton argument that it amounted to a material non-disclosure. For your lordship's note, tab 10, page 196, paragraph 53. So it's part of our case before the judge. Secondly, that the claimant's financial position wasn't strong, and that therefore the second claimant's parent, PCPF, could provide a cross undertaking as to damages, but the draft order didn't contain that cross undertaking from PCPF. And when
This is not a finding which the judge made, is it?
yes,
He says at 23 he won't reach a firm conclusion on the other matters complained of, but he'll just mention this point.
that is not my reading of it. So if I can show paragraph 23, page 59 to 60, he says, without reaching a further conclusion on the other matters complained of by Mr. Solomon, I conclude overall there's a serious failure to make full and frank disclosure of relevant matters. I'm not in a position to conclude it was deliberate, but can certainly be described as culpable. Of the other matters raised, I'll just mention the failure to include an undertaking as to damages by the second claimant's parent company. On balance, I consider it as inadvertent. However, it's right to criticise the claimants or their representatives for not immediately correcting the omission when it's drawn to their attention. We read that as meaning that that was part of the failure that the judge had found. And it's correct, we didn't include it in a respondent's notice because that was our reading. And we say it is a failure. So what happened?
But even then, when you get to set 24, given the overall serious failure, I must confess whether or not the cross-undertaking or the failure to correct errors in the cross-undertaking were found to be material non-disclosure. And most of it was inadvertent or subject to criticism, but I didn't get the sense it was part of the things constituting the overall serious failure justifying the setting aside.
our reading of it was that it was that although the original failure not to include PCPF in the draft order was inadvertent.
It's the failure to criticise, to correct.
Exactly. So
I suppose we got your submission about it. but-
there we are. I'll be very brief on continuation and regrant, but make a couple of points if I may. Discharge and regrant. First, it is a high hurdle to show that the judge erred in his discretion. And in respect of such a discretion, given the seriousness of the failures, my submission is that Alan Boyle QC, sitting as a deputy High Court judge's judgment is right, that the general rule that is that the order should be discharged, and that any regrant should be done sparingly. And sparingly is a word you see in many cases, my lord, not just in the Corporation and Schroeder case. So, given that this is a judicial discretion, and that the decision to continue or regrant should be exercised sparingly, it's a very high hurdle, we say, to overcome for the claimants to show the discretion was exercised wrongly. Can I just have one moment?
Yes. You can hand over to Mr. Sanders for the last 5 minutes if you like.
I'd be delighted to do that. Can I just take one? I'm sure he's looking delighted at that prospect as well. 869. Yes, I can thank Mr. Sanders for this. My Lord Justice Lewis asked me whether the general rule can be found in cases other than the deputy judges, and I'm happy to refer to a Court of Appeal case behind tab 31, the case of Val Bond and United Homes. At the end of it, paragraph 62, first, as Christopher Clark J pointed out, where there are breaches of the duty of full and fair disclosure on a without notice application, the general rule is that the order should be discharged and the court should refuse to regrant. And Mrs. Justice Carr, as she then was, adopted the same approach in Tugashaw. So it seems it is a general rule. On the exercise of discretion, we say that it simply can't be said that the judge ignored the overall picture and completely overlooked my client's admitted breaches. And this is unsustainable in the context that my client's admitted breaches were front and centre of the claimant's submissions before Mr. Justice Bourne, and formed the main part of Mr. Justice Constable's judgment, which Mr. Justice Bourne had set out. And Mr. Justice Bourne recorded that my client had made important admissions. So it simply can't be right that somehow my learned friend is able to say that Mr. Justice Bourne ignored the interests of justice. Here, in terms of the regrant of the injunction, just a few facts are relevant. First, the judgment of Mr. Justice Bourne was on the 17th of October. On that date, there was no application for permission to appeal, no oral application, much less an application for an expedited appeal, nor was there any application for interim relief pending any appeal.
Must have been well past 5 o'clock when you'd finished giving judgment, wasn't it? Or was it late?
Yes, maybe, I can't remember.
A bit harsh to
Well,
make that point.
And what does it matter? They didn't.
They didn't.
And they have now.
They have now, but we're now in January, just, and the non-compete lasts until March. This was in October. And so they haven't asked for any interim relief and they didn't act promptly. So the application for permission wasn't made until the 28th of November. They're asking now for you to make an injunction from whenever your lordships hand down judgment until March, when we've been from October to
In that
January.
case, you'd be very lucky. You haven't had an injunction for the last 4 months. I can't see why it's relevant.
Well,
Either they should get one or they shouldn't get one.
a party isn't entitled to sit on its hands and then demand urgent injunctive relief. It's asking this court to exercise its discretion, and it hasn't. The claimants, appellants, haven't acted promptly.
Are you submitting that since October, Dr. Ali has been busily competing away,
No.
and that an injunction now would prejudice that, which he wouldn't have done if he'd realised earlier there was going to be an application for permission to appeal?
On the contrary, my lord, there is no evidence at all that there's been any competition by Dr. Ali since October. I was criticised for saying that Dr. Ali doesn't intend to compete pending the trial. That's a matter that Mr. Justice Bourne was plainly entitled to take into account. That's a matter to Dr. Ali's credit.
Well, I mean, I just wonder what the passage of time point goes to, if not that.
It's obviously prejudicial to Dr. Ali if he's subject to a penal order with contempt.
It would only be subject to that if it's right to make such an order. And the fact that the application wasn't made into a particular point, and the fact that his name didn't order expeditions or whatever it is, I don't see how that affected either.
Well, perhaps I
They're
can.
entitled to it, or they're not.
Perhaps I can put it like this. Delay is often relied upon as a reason for refusing to grant interim relief. That's point one. Point two, there's been no evidence of any breach between October and now, and the non-compete could only last from your lordship's order until March. And so it seems to us that the real reason this is all being advanced is because of costs. Can I quickly, before I address you on costs very briefly, can I quickly address your lordships on adequacy of damages? And it was said repeatedly that this was a point that Mr. Justice Bourne had dreamt up himself. It wasn't. I did interrupt rudely to say I'd made that submission before, Mr. Justice Bourne. For your lordship's note in the transcript, it's page 317 of the supplemental bundle. Behind tab 13. And the reason I made it was relying on Mr. Terry's own evidence, was that when he said his paragraph 117, I'm reading from about paragraph D on page 317, I referred to Mr. Terry's 117, where he's worrying about further damage being inflicted, and I said they're worried about further damages being an adequate remedy or a reason for not granting an injunction. So none of this explains why they're going ex parte. So I have made submissions about damages being an adequate remedy based on the claimant's own evidence. Now it may be that you don't think my submission was very good, but that's different from saying that Mr. Justice Bourne dreamt it up himself.
To assist the court, perhaps I wonder if we can show where he said it in his 45-page skeleton argument.
He doesn't need to. I mean, he's clearly raised the point before the judge, and to be honest,
Yes.
the judge hasn't dreamt it up. It's what American Signing Law says.
Yes.
Yeah.
Yes, and in the context of a share sale where a business is selling, a business is buying another business for an amount of money, which is value. We know what the value of that business was. In that context where the claimants are saying, you've taken our business, we know what the loss is because it's the value of the business. So that is obviously, damages are an adequate remedy. I'm going to, if I may, address respondent's notice and costs in totality in 5 minutes.
Go on.
Thank you. On the respondent's notice, can I make 4 points? One, we say Mr. Justice Bourne fell into error because first, the remaining earn-out payment was a significant amount of money, 633,000. I know that my learner friend Mr. Kimman dismisses this, but in anyone's view, that's significant. Secondly, this was a key part of the price under the contract, this earn-out element. Thirdly, the ongoing failure to pay it went to the root of the SPA. And fourthly, there was no cogent or any response to our position in relation to the no set-off clause. So in that context, on those agreed facts, the claimants had plainly shown an unwillingness to be bound by the agreed terms. And we say that was a repudiatory breach, entitling my client to accept it and then discharge him from ongoing compliance with the contract himself. My learner friend Mr. Kimman says it's unattractive. It's an unattractive position for my client to take. It's unattractive for him to say that he wants to be paid hundreds of thousands of pounds in respect of contractual obligation in which he's owed that money. It's not unattractive. It's unattractive for the claimants not to pay it.
Well, you could have made a cross-application for summary judgment for the whole claim to be dismissed on the basis that everything your client had allegedly done is wholly irrelevant. He was clearly entitled to treat the contract as repudiated, and that'll be £633,000 in interest and costs, please.
We hadn't accepted the repudiatory breach at the date of the interim hearing, the inter partes hearing.
No, but by the time you got to Mr. Justice Bourne, you certainly had. You're saying he should have made a finding that...
We didn't. I accept we didn't. So, but the facts, we say the facts are so clear that that's the only position he could reach. I take your lordship's points, and I understand your lordship's preliminary conclusion expressed to me earlier. Can I turn to costs?
Yes.
My learned friend said on a number of occasions there were very, he said, in fact, two verys, serious cash consequences for the claimant. And that might be the real reason for this appeal. £700,000 he estimated it at. Now, four points on costs, if I may. And a submission on the law. Submission on the law is, presumably, it's unusual for this court to be troubled with appeals on costs. They are classically a matter of judicial discretion. It's very difficult to show that the discretion was exercised improperly on costs. But the 4 points are, first, the claimants themselves, in their skeleton argument before Mr. Justice Bourne, sought their costs. Behind tab 9, page 174 to 5, paragraph 75 to 79, they're saying they accept the normal rule as cost reserve, presumably, but paragraph 79, D's position in this matter is the antithesis of the sensible approach. It's submitted that the position is so clear and the outcome of the application so plain that an order that D pay sees costs of the two hearings is plainly merited. Two hearings being the ex parte and return date. Or in the alternative, at least the cost of the on-notice application and the return date, because there was an adjourned hearing. So they were seeking their costs. Their costs are behind tab 11. This is where we get the 500,000 point. The cost they were seeking amounted to £500,000. They weren't saying we're not entitled to some of these costs because they're costs of the case. They were saying we're entitled to all our costs of these applications. They're all costs of the applications. So you can see the three cost schedules at pages 212, 218 and 227 are respectively 147,000, 248,000 and 102,000, amounting to about, I suppose my learned friend's right, about 500,000. So these are the costs they wanted. Thirdly, the submissions below were not the submission made now that the costs of the claim should be subtracted from the cost of the application, and the costs of the claim are going to be separate and should be decided by the trial judge. You can see what the submissions below were, because we've got the submissions at the back of the, at least I hope you have, at the back of the supplemental bundle. Is it in the core bundle? I don't know. No, I think it's supplemental bundle. Page 718 onwards. Those are the claimant's submissions. I hope your lordships have those, because they were added relatively recently.
They were, this can be condensed into, they were applying for all their costs,
Yeah, and
not the particulars of claim, for example, which costs in the claim rather than
they hadn't filed particulars of claim. Yeah, the particulars weren't included.
and it was a huge amount of money. Right, that's the first 3 points, and the fourth is
Yeah. So their submissions, when Mr. Justice Bourne asked for written submissions, their submissions did not take the point that my learned friends now take, that cost of the claim should be subtracted. They were taking other points.
Yep.
And so in that context, Mr. Justice Bourne went through all the points that the claimants made in his judgment on cost behind tab 5. My learned friend only read out one paragraph, but all of the points behind tab 5 at page 48, paragraphs 1 to 3 are the substantive reasons advanced below as to why the claimant shouldn't pay our costs. Why we shouldn't get a cost order in our favour. It's not the same point as they're advancing now. And so Mr. Justice Bourne's judgment is unimpeachable in this respect. He dealt with the submissions before him. He's entitled to come to that conclusion, especially given that he determined that there'd been material non-disclosure.
yes.
My learned junior reminds me, sorry for not letting him make this point himself, that they accepted in their submissions that they should pay. They said the claimants accept the defendants were the successful party in the continuation application and the discharge application, and that in accordance with the general rule in CPR 44, they should be ordered to pay the defendant's costs of those applications. And so that includes my client's witness statement, which my learned friend has complained about, including his admissions, but they accepted that below. So it's not open to him to appeal that point now. I've invited Mr. Sanders to say something, but he's declined.
Then I will simply call on him, and he can bow in accordance with tradition, and thank you very much. Any questions? Shall we rise for a minute? We'll just rise for a moment.
Sorry, I'll let you two.
No, 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 come in, come in.
This one was the 27th of June. This is a draft continuation. And we're saying and piece. And saying it's on the table. It's on the table. It's always been on the table.
don't wish to hear submissions in reply by Mr. Grant. We have come to the conclusion that provided an undertaking in damages is given by the claimant's parent company by 4 p.m. tomorrow, the appeal should be allowed. A non-competition injunction should be granted until the 24th of March 2024. This would be in the terms sought unless written submissions about the wording are lodged by 4 p.m. tomorrow, but we don't understand there to be a problem about the wording of that injunction. We also think that some form of injunction or undertaking is justified to protect the claimant's properly protectable confidential information. The wording sought by the claimants is unsatisfactory, as Mr. Grant conceded. We hope that it's possible for agreement to be reached on a proper form of words if agreement can be reached, a minute of the agreed wording is to be lodged by 10 a.m. on Friday of this week. If it can't be, then we invite written submissions first from the claimants by 4 p.m. on Monday of next week, 5th of February, and from the defendants by 4 p.m. on Wednesday of next week, 7th of February. We will give our reasons in writing in due course, and we will ask for submissions on costs to be exchanged and lodged within 7 days after the written reasons have been handed down. We're very grateful to Council for their oral and written submissions. I hope what we say has covered all the points which we need to cover today. Please say if either of you thinks we have.
Thank you so much, my lord. I'm very grateful. Can I turn my back on your
Yes, of
court
course.
for a second?
Yes.
My lord, for my part, that I think covers everything in a highly satisfactory way.
Mr. Solomon.
I think that covers everything. I wouldn't go as far as say highly satisfactory way, but
No.
I do think it covers everything.
Well, Mr. Solomon, we are very grateful for your submissions in particular. You did not prevail, but you fought with great distinction.
Grateful.
Thank you all very much for your assistance.